the appellants, and if I could, I'd like to reserve 2 minutes for rebuttal.
2 minutes, sir. All right, you may proceed.
Thank you. Your Honor, this is an appeal from an order on a motion to dismiss where the appellants really have no quarrel with any aspect of the trial judge's order and opinion except that which concerns the extraterritorial application of the TPLA, and that's what I would like to address this morning. But before getting into that issue, I just wanted to make a couple points. On page 13 of the brief of the appellee Drexel Chemical Company, just want to make clear to the court, I think this is just for background purposes, that the appellants don't concede that either Drexel or its contracting party in the Dominican Republic complied with Dominican law with regard to the pesticides or the herbicides that are at issue in this case. Specifically in paragraph 366 of the complaint, the appellants alleged that the defendants violated that Article 4 of Law 311 of the Dominican law, which concerns labeling of their herbicides, because the labels don't communicate to the appellants in a language or a method or a manner that they understand how to prevent injuries to their health. But turning to the most important issue, which is whether the TPLA can be extended extraterritoriality, we submit that there are four issues that the court needs to decide in arriving at a resolution of that issue. The first question is, what is the focus of the TPLA? The second question is, what conduct alleged in the complaint is relevant to the TPLA's focus? The third question is, did the relevant conduct occur in the United States? And the fourth question, which is based on Justice Stevens's concurring opinion in the Morrison case, is what adverse effects would result in the United States if the scope of the TPLA is not extended extraterritorially in this case. So turning to the first question, what is the focus of the TPLA? The appellant's position is set forth at page 17 of its brief, and at pages 14 and 15 of the appellant's brief, we set forth what factors are to be considered by the court in determining what the focus is. And it is up to the court to determine what the focus of the TPLA is. We assert that the focus is not, as the Drexel asserts, to codify and put limitations on product liability claims, but rather the focus of the TPLA is the responsibility that it imposes on manufacturers and sellers to produce and sell products that are safe and not defective or unreasonably dangerous. Now, the extraterritorial application, we also take the position that the extraterritorial application of the TPLA would not violate any of the choice of law principles applicable in Tennessee, and it would not violate or contravene the intent of the legislature in enacting the TPLA in the first place. Now, the Drexel makes reference to the fact that the word ordinary is used frequently in the TPLA, as somehow indicating that supports their position with respect to what the focus of the TPLA is, a consumer focus. But it's our position that is not correct, and we would also point out that this court should reject their contention that the trial court made what they have referred to as a Scrivener's error, and it meant to cite section 29-28-105D of the TPLA instead of citing section 29-28-105B of the TPLA in support of its conclusion about the focus.
Let me ask you a question.
Sure.
Just for argument purposes, let's say that you're correct in the presumption in the extraterritorial application is not applicable. It appears from Justice Wagner's order that it's the first time I've said that. Justice Wagner's order that she seems to give an alternative with a Tennessee choice of law provisions as another avenue as to why this litigation should come to an end.
Yes, however, the case cited by Judge Wagner is really a forum nonconvenience case. It's not an extraterritorial application case. She is using, at least in our view, the trial court judge used the choice of law issue to try to buttress her conclusion that, based on her analysis of the language of the statute, that the TPLA could not be extended extraterritorially. It is not an alternative basis for finding that the TPLA could not be extended extraterritorially, because
she goes into some detail as to why this choice of law theory may be applicable. She says all injuries occurred in the Dominican Republic, all use of the products occurred in the Dominican Republic, any proof regarding the use of the products, which products were used, what amounts of products were used, when the products were used, yada, yada. All of this, she's going through a whole series of facts that you would use in doing an analysis of a choice of law.
Right, but correct. However, that analysis is incomplete, because what the trial court has stated as to what the relevant conduct is incomplete. It's not simply a question of where the injury occurred, but context matters, and that's what the Morrison Supreme Court case says. Context matters when you determine what the focus of a particular statute is. And in this context, the product liability context, what also matters is how was this product designed? What went into the design? Was it tested? And particularly in this case, how were the instructions, safety instructions prepared? How was the labeling prepared? All of these things occurred in the United States, not in the Dominican Republic. So
But
to be sure.
under the choice of law theory, isn't it where the injury occurred? Isn't that the idea?
Lex loci, you can certainly make that argument, but again, I would assert that the RJR Nabisco case does not state that a forum nonconvenience analysis is what the courts are to resort to when they determine what the focus of a statute is for purposes of determining whether that statute should be applied extraterritorially. Although it is up to an individual court to make that determination, the Morrison case sets forth expressly what the courts are to look at.
Because RJR is interpreting federal law and federal application, isn't it? Federal statute.
Yes, it is, but RJR is the case that has been accepted, certainly by the parties here and other cases, at least that I've researched, that you have resort to when you try to determine whether a particular statute has an extraterritorial application. You have to focus on the statute itself. Forum nonconvenience analysis doesn't focus on the statute. Forum nonconvenience analysis focuses on facts specific to a particular case, which, as I indicated, the trial court's analysis on forum nonconvenience is incomplete because it doesn't consider those decisions that certainly were made here in Tennessee and not in the Dominican Republic. Morrison indicates that an analysis of the statute, its legislative history, and things of that nature are what is necessary to analyze to determine what the focus of the statute is. Drexel relies on the Penley case to try to argue that, to support its position as to what the focus of the TPLA is, but that case, at least as interpreted by Drexel, has been extremely misinterpreted. Penley just makes clear that the TPLA came about in Tennessee in 1978 because there was a concern about the high cost of insurance premiums that manufacturers were paying because of a lot of product liability suits. And Penley states that the focus, that the motivation was to put time limitations on when someone could bring a product liability action. It had nothing to do with the scope of a product liability action brought against a Tennessee manufacturer. Penley just said that we need to set forth specific time, statutes of repose, statute of limitations, what have you, so that you can't sue forever. But in this particular case, these 165 plaintiffs are suing within the statute of limitations, and that's what the trial court essentially did not conclude, but the trial judge stated that there are certain factual questions that need to be addressed in discovery before she could arrive at a conclusion whether or not the statute of limitations knocked out some or all the plaintiffs, whether or not the statute of repose knocked out some or all the plaintiffs. And we certainly agree with her in that respect. But with respect to the extraterritoriality of the statute, we disagree with her conclusion as to what the focus of the TPL, what the TPLA was. So Penley is not the case that defines what the focus of the TPLA is. We submit, and as we discussed in our brief, that the case Ray by Holman versus BIC Corp., which is at page 22 to 23 of the brief, and the analysis that we did of that particular case clearly indicates that the appellant's position with respect to what the focus of the TPLA is correct. If I could get to the question of the application of choice of law principles, we've already discussed. But the question of what conduct occurred is an issue for this court to decide, and it's decided on a case-specific basis because, as Morrison says, context matters. Drexel relies on the Nestle case, but it's our position that Nestle does not control here. Because in the Nestle case, which is where the plaintiffs asserted that there was a forced labor, essentially a conspiracy with respect to the production of cocoa, there was a reference to so-called operational decisions, which the plaintiffs alleged indicated that the statute, operational decisions made in the United States, which meant that the statute, the ATS, could be applied extraterritorially. However, operational decisions was not defined by either the plaintiffs or the Supreme Court for that matter. But in this particular case, the decisions that were made in Tennessee are very specific with respect to what is the chemical composition of the herbicides that that Drexel chooses to manufacture. What testing are we going to subject these herbicides to determine what health effects they have? What are the alternative formulations? Things of that nature. And the complaint goes into great detail about the chemical composition of the herbicides, the mode of action of how it causes injury, the issue with respect to whether Drexel did adequate testing, whether they considered alternatives to the composition of the herbicides that they presented. And certainly it goes into great detail with respect to the labeling issue. And I would submit to this court that that is an issue that is certainly relevant to what conduct is relevant to whether the statute could be applied extraterritorially in this context, because at least as early as 2018, Drexel knew that its intended audience in the Dominican Republic were people who did not speak or read Spanish, but rather spoke and read Haitian Creole, yet they chose to print their labels in Spanish, which does nothing to help my clients make sure that they understand exactly what they're applying, how to apply it, and how to take precautions to protect their health. The third question.
You used your time.
I'm done. I'm sorry, Your Honor. I do have 2 minutes, I presume.
You do, yes, sir.
All right. Thank you, Your Honor.
Thank you.
Good morning, Your Honors.
Morning.
My name is John Woods, along with Ken Allen. We represent the appellee Drexel Chemical Company. And before I begin, I want to take a moment and express that it's a privilege for me appearing before you, Judge Golden. I'm a younger member of the bar, so to appear before you in your last oral argument, I take a profound respect in doing so, and I hope that that this matter contributes to your finding of the seriousness and importance of this court. I heard what you said, that you find this court to be a backbone, a vertebra in the backbone of our democracy, both in the state, and I think fair to say, under the common law in this country. So I appreciate that. So may it please the court, this is a case about the fundamental principles of our democracy, of what this court is supposed to do in this state. What you did not hear from my opposing counsel is that this is a case about international plaintiffs, foreign plaintiffs, who are injured in a foreign country looking to apply Tennessee law against a Tennessee defendant, specifically the TPLA. These plaintiffs have asked, and they explicitly stated it in their brief, that they think that under their principle, Tennessee law should apply to plaintiffs anywhere in the world. That plaintiffs anywhere in the world, wherever they were injured, wherever they are from, can sue under Tennessee law. That contravenes a specific, long-held, fundamental principle of common law jurisprudence in this country and in this state. The trial court, Justice Wagner, properly found that the TPLA has no extraterritorial application, that it does not apply to conduct or to injuries occurring outside the state of Tennessee. It occurred to me that there is an even more fundamental principle, and again, one which plaintiffs' counsel has overlooked in this, that going back to the choice of law issue, is that we start with where were the plaintiffs injured? That is the first question that we look at when we determine whose law applies. For 100 years, Tennessee's decision on this, like every other common law jurisdiction, was lex loci delicti. The law of the place of injury governs. Now, maybe the law of the place of injury may determine that someone else's law applies. They may. But you start with the law of the place of the injury. Here, the place of the injury was in the Dominican Republic, not a part of our nation. And as we asserted in our Rule 27 supplemental brief to the court, or supplemental citations to the court, at the passing of the TPLA in 1978, Dean John Wade observed that the law that governs liability is the state where the injury occurred. That was true in 1978. That was true in 1890, when the Tennessee Supreme Court adopted lex loci delicti. And the Hadaway case is the authority for that. And that was true in 1992, when the court adopted the secondary statement, which we have now as the most significant relationship test. This is what governs the law that applies. Plaintiffs have tried to assert the TPLA applies extraterritorially, and it's frankly wrong. The law that applies is the law of the place of the state where they were injured. In this case, it's the Dominican Republic.
What do you say about whether or not that Tennessee's choice of law provisions would be applicable here, should we determine that the extraterritorial application is not applicable to Tennessee?
I think first we'd have to get past the question of the extraterritorial application. Secondly, have plaintiffs asserted a claim under the Dominican law, and they have not in this case. As plaintiffs noted at the end, they have asserted these claims. Plaintiffs' counsel has asserted these claims on behalf of similarly situated plaintiffs in 3 separate states. This is the 5th complaint that they have filed. The plaintiffs' counsel has filed for these kinds of plaintiffs. In this particular instance, and each time they've refined their claims, and in this particular instance, they have removed all allegations or all causes of action of the Dominican Republic. So the first question is, the first question the court would have to look at is, what law applies? In this case, under a choice of law analysis, as the trial court noted, it would certainly be the law of the Dominican Republic. A similar analysis was done by the court in the Bridgestone Firestone cases, which we cited in our brief. The court reached the exact same analysis, and it concluded almost certainly the law of the state of Mexico would apply. So yes, I think the court would have to then go to the second conclusion of the choice of law analysis. But that presumes that the court has jurisdiction over these claims and should assert that analysis. Here, they asserted a claim for the TPLA, and taking, the plaintiff's the master of their complaint. Taking the complaint, as we're presented with it, it simply fails to state a claim under the TPLA. They asserted causes of action that accrued in the Dominican Republic for conduct that occurred in the Dominican Republic. As you noted, Judge Golden, that Justice Wagner, when she was going through this analysis, found that all the relevant conduct that plaintiffs allege in their complaint occurred in the Dominican Republic. So almost certainly that law would apply. And for that reason, the complaint should be dismissed as well. Now, it was stated in our motion to dismiss, that was an argument in the alternative, should the court have reached should the court not have reached the conclusion it did on extraterritorial application. But I want to draw the court's attention to an argument that Mr. Vance made in his statements to you, that we do not quarrel with any other aspect of the trial court's decision, and that's incorrect. The court did conclude that that there is no extraterritorial application of the TPLA. We do agree with that. As a secondary argument, however, we did assert that the statutes of limitations and statutes of repose should foreclose any alternative cause of action by the vast majority of these plaintiffs. Again, it may not be a point that the court has to reach if this court affirmed the extraterritorial application argument made by Justice Wagner, but I do want to note that is not the case, that we have conceded that we have no other quarrels with the trial court's analysis. If you have any questions, I'm happy to discuss that, but I don't know that it'll be necessary. And secondly, there was an apparent dispute as to what plaintiffs have conceded and what they have not conceded regarding Dominican law. The brief and the arguments asserted by the plaintiffs assert that fail to disclose or fail to attach the labels that are really at issue in this case. And they made substantial reference to them throughout their briefs. They then acknowledge that those labels did comply with Dominican law, and they say that that's not relevant to any court's analysis. But they do admit and acknowledge that we did comply with Dominican law in those labeling. Now, they say that was insufficient, but that doesn't mean that we did not meet the requirements of the Dominican Ministry of Agriculture in providing those labels. Finally, I want to take an opportunity to discuss something else that I heard from plaintiff's counsel, which is the repeated reference to the United States Supreme Court Morrison case for his authority. And he briefly mentioned it in his remarks, but each time in plaintiff's brief that they rely on the Morrison case is in specific reference to Justice Stevens' dissent in the Morrison case. It is not the holding or the opinion adopted by the majority of the United States Supreme Court. It is a dissent. And in reference, and Justice Stevens' dissent is discussed at some length in the majority's opinion, in the context of the case that they were deciding came from the Second Circuit. The Second Circuit had adopted an extraterritorial application analysis, which, as the court, in the court's words, tried to divine the intent of Congress. If only Congress had thought of this, potential application of the law when they had written it, surely that would have been how they wanted the law to apply. That's essentially what the plaintiffs are arguing here. That, Congress, the Tennessee General Assembly, did not put in any express application of extraterritorial application. I think we have agreed on that between the parties. There's no explicit application. That's the first step of the extraterritorial analysis application. So let's look at the focus. And he says, let's look at the context. Let's look at the intent of it. Well, that is exactly the Second Circuit's analysis that Judge Stevens was asserting or pushing for, that the United States Supreme Court explicitly rejected. They asserted that was an attempt by the court to impermissibly step on the toes of the legislature. The legislature wanted that. The legislature should have said so. They didn't say so, so we cannot now. And it's improper for a court to make a determination that the legislature didn't. And that is the entire basis of the plaintiff's argument. They want to divine the intent of the legislature, and that's simply, I think, inappropriate for any court to do so. Again, considering the separation of powers, this court's job is to apply the law as it was written, not to attempt to divine the intent of the legislature, where they clearly did not intend such an extraterritorial application. I think if the court wants to look at what the legislature does when it intends to have an extraterritorial application, is look at the workers' compensation statutes in Tennessee, which maybe until 2010 or 2012, when the law was amended, it had a specific provision in there stating extraterritorial application. Now, and the substance of the law is largely the same. They did, however, take out the term extraterritorial application, but the legislature knows what it's doing when it intends to do that. They chose not to in this instance. I don't think it's appropriate that this court decide that foreign plaintiffs injured overseas should be allowed to use the Tennessee court system as the world's court. That is not what Tennessee laws are for. They're designed to protect the citizens of the state of Tennessee. If plaintiffs have a claim, they should bring it in the Dominican Republic. So I'll take a few more minutes and just say that I want to emphasize the importance of this fundamental, this first principle that I certainly overlooked at the outset and took it for granted. It certainly wasn't addressed by the plaintiffs or in their briefs or oral argument. And that goes back to, we first looked to the law of the place of the injury. For over 100 years, it was lex loci delicti, and now it's a secondary statement, the most significant relationship test. The most significant relationship, as Justice Wagner noted, is the Dominican Republic. Plaintiffs have no basis to assert a claim in Tennessee. They simply do not. They've presented no case law. They've presented no statute. They have presented no good reasoning or authority in any court, from any court, for why they should be allowed to maintain their claims. 165 Haitians living in the Dominican Republic want to use a Tennessee trial court for recovery of injuries they sustained over the course of 50 years in the DR. That's simply not what our courts are designed for. If they want recovery, they should seek it in their own courts. With that, I'll follow Mr. Jenkins' lead and offer to sit down before my time is up. I'm happy to answer any questions that the court has.
See none.
Thank you, Your Honors.
Thank you. First, let me make clear, in the Morrison case, Justice Stevens' opinion is a concurring opinion. It is not a dissenting opinion. So it is entitled to weight. Secondly, I would submit that the court should reject these kind of doomsday pronouncements from defense counsel that this case is designed to expand Tennessee law all across the world. But what I think the court should consider is that the TPLA has as its focus making sure that Tennessee corporations manufacture products that are safe for the users wherever they may happen to use them. So it's not a question of trying to open up this court to any foreign plaintiff against any Tennessee manufacturer, but is specifically geared toward the responsibility that the TPLA imposes on Tennessee corporations to manufacture products that are safe and do not injure the users. Also, as this court is well aware, the reference to the statement made in before the legislature in 1978, the law is a constantly evolving thing. And R.J. Reynolds is a perfect example of that. And finally, I would make 2 points. One, this case does not rise and fall on the issue of the labels, because that's certainly just one fact relevant to the claims made by the plaintiffs under the TPLA. And choice of law is not an issue right now. It might be later on, but it certainly is not now. So with that, Your Honors, thank you, and we would request that the court reverse the extraterritoriality finding of the lower court. Thank you.
Thank you. Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may be excused.
Thank you.